reporting to the court.
All right, how are you, Ms. Wilson?
I'm doing well. How are you, Judge?
Good, I'm good. What's the first case we're going on to?
Did I hear that Moscow was on Zoom?
Who knows?
Okay. Well, in that case, I think we're ready on Woods.
All right, Woods. What's that?
Raina Jackson was a waiver too.
Oh, Jackson was a waiver too.
Yes.
We're going Woods and Jackson.
Yep.
Can I approach, Your Honor?
You may. All right, thank you. All right, so we're on the record in docket 23-02411. That is people in the state of Michigan versus Dayton Woods. Would the parties please introduce themselves for the record? She needs to be on the Ms. Wilson.
Abigail Wilson.
Mr. Dillon.
Luke Dillon on behalf of Dayton Woods, who's present standing to my left.
And sir, you are Dayton Lamar Woods?
Correct.
Thank you. This is the time set for a preliminary examination today. Miss Wilson, how we proceed?
Thank you, Your Honor. I believe this is going to be a plea to a misdemeanor of use of a narcotic / cocaine / ecstasy. And that is a 1-year misdemeanor and or $2,000. And I have the PAC code ready when the court is.
So it's 1 year, enter $2,000, plea to use.
Correct. And that would be an added count. And then dismiss the count 1.
Added count 2. Dismiss count 1. And what is the PAC code?
333.74042A. And there's no objection from the people to 7411 status if the defendant is eligible.
And Mr. Dillon, is that a fair statement of the plea agreement?
Full and accurate statement, Your Honor.
All right, thank you. May I inquire of your client of his plea to the added count 2 of use under 333.74042A?
Please.
Mr. Lamar Woods, you understand the maximum penalty that I could sentence you to under the plea to a use under count 2 is 1 year and or $2,000. You understand that, sir?
Yes, sir.
All right. You have signed an advice of rights that have indicated your 12 rights and your understanding of it. That's correct?
Yes, sir.
I'll just go over the 3 main ones. You understand you have the right to be tried by a jury. You have the right to counsel. Mr. Dillon would be present at jury trial to cross-examine any witnesses for contesting any charges brought against you by the people of the state of Michigan. And you have the right to remain silent. The people can't call you as a witness against yourself. Do you understand those rights, sir? All right. It is my understanding if you're please accepted, will give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from a trial. Since you won't be having a trial, you'll be pleading guilty instead. Is it your intent today to waive your rights as indicated on your advice of rights and to plead guilty today to the count 2?
Yes.
Can I have you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? I'm going to bring your attention back to May 28th of 2023 at the location of Martin Luther King Boulevard and on Holmes in the city of Lansing. Were you on Martin Luther King Boulevard, Holmes in the city of Lansing on May 28, 2023?
Yes, sir.
And at that time, did you use or intentionally use a mixture containing either cocaine or heroin?
Yes, sir.
You did. And when you used it, you knew it was cocaine or heroin. All right. Anything towards a factual basis, Ms. Wilson?
Not from the people.
Mr. Dillon?
None from the defense.
I find the factual basis to be knowing, voluntarily, and accurately made. And we will send this to probation. There is an agreement. There's an agreement that the people will not have an objection to 7411 status that'll be part of the report they do for us, okay? I do see that objection, that agreement to 7411 status, if probation recommends it without objection to it. And so what they're gonna do is I'm gonna send you to the 5th floor. They're gonna either give you a date or they're gonna do a report for you. And they'll prepare a report for me, and then we'll see what options are available to us,
Okay.
right? So refer to probation. And we'll set the sentencing for
The works of Mr. Dillon's schedule, June 20th at 8:30.
June 20th at 8:30. Does that work, Mr. Dillon?
Yes, that's fine.
All right. All right. So go down to see what date they have available for probation, and then we'll see you on the June 20th date. Okay, sir? All right. Thank you.
Thank you, Your Honor. Thank you.
Thank you, Mr. Dillon. And then Mr. Blackman's here on.
Jackson.
Mr. Blackman, how are you? Sure. Right, so we're on the record in docket 24-00425. That's people in the state of Michigan versus Marino Jackson. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Your Honor, Fred Black on behalf of Mr. Jackson, he's staying to my right at 40.
And sir, you are Marino Jackson, is that correct?
That's correct, sir.
Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe this is going to be a waiver of the preliminary examination that people also unconditionally waive.
And is that a fair statement, Mr. Blackman, with negotiations to continue?
That's correct.
May I inquire of your client of his waiver of the preliminary examination?
Can, Your Honor.
Thank you. Mr. Jackson, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Fred Blackman, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a preliminary examination, have this case continue on to circuit court where negotiations are going to continue.
Yes, sir.
Is that your wish today to waive your right to a preliminary examination?
Yes, Your Honor.
And Ms. Wilson, you also waive your right to a preliminary examination?
The people unconditionally waive their right.
All right. I find that the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And now you will give the documentation for each party to sign. But I'll indicate that the examination has been waived on today's date. Anything else for the record? We can docket 24-00425, Ms. Wilson.
Half of the people.
Mr. Blackman,
Briefly, Your Honor, if I could.
you may.
My client is currently on a tether with this court. There was a companion case here that initially was arraigned on and placed tether on. There was a victim in that. And so I had a tether on. That case was dismissed. Subsequent to that, he's posted bond on here, and I think that the tether continued on this particular case as a result of the other one. I have a case with Mr. Marino down in Eden County right now. The file number is 24-0165FY. We have a probable cause conference Monday on that matter, and got a $500 cash surety bond on that. Checking in pretrial services. when they need him. He's been dropping for both counties. He's been doing everything he can. There's been no problem since he's been on tether for the last 60 days. I'm asking the court if the court would remove the tether from my client because of the expense of the tether now, and he's been complying with everybody. We at one time wanted to go to the state of Missouri. We had emailed pretrial services to allow him to go because there's a specialized dentist for his teeth. We never got back, so he never left. He has not violated the tether, and he's been really good right now, Your Honor. So I'm asking the court would take that off.
So the GPS is just for, it's for monitoring purposes.
Yes.
There's no contact order. Ms. Wilson?
I would think it's at the court's discretion.
There's never been a no contact order in this case.
No.
Not in this file.
All right. You said the defendant has a probable cause conference in another county.
That's correct. In Eaton County with Judge Morton, Your Honor, on Monday. I represent him on that matter.
All right. Well, I'm going to remove the GPS. Since we don't have a victim notification of any kind, this is really I don't have any failed to appear up for the PCC was in February. At that time, Mr. Black, you were not involved in the case.
No.
I was previous to you because you got involved in March 7th. You were just retained on ours. So I'm going to indication since you've been on the case, there have been no bench warrants or bond forfeitures. So I'm going to remove the GPS with the understanding you're still involved in the case, that you're still involved in the circuit court case in Eaton County. So remove the GPS, and that would be, and then we will contact the monitoring device to tell them it's being removed. I would give it about a day to purge from the system, okay? Just to avoid any kind of bond violations.
Okay, sir.
So remove the GPS for monitoring. That may be revisited by the prosecutor in circuit court, but you'll have to deal with that when we get there. Anything else from the record on docket 24-00425, Mr. Black?
Nothing, thank you.
All right, thank you. Thank you. That's all, and I'll sign the document and we'll be all set. So that's Brittany Munson.
Yes, sure.
And ma'am, you are Brittany Moscow, is that correct? You'll have to unmute if you can, or there you go.
Good morning.
All right, and ma'am, you are Brittany Moscow, is that correct?
Yes, Your Honor.
All right. So this is the time set for sentencing in the matter. This is people of the state of Michigan versus Brittany Moscow, docket 23-01848. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Brittany Moscow, who is present and joining us by the Zoom application from the Eaton County Jail.
Thank you. And ma'am, once again, you are Brittany Moscow, is that correct?
Yes, Your Honor.
Oh, yeah. And you can hear me all right, Ms. Moscow?
Yes, Your Honor.
Thank you. This time set for sentencing in the matter. Is there any restitution on this file, Ms. Wilson?
Let me double check.
I
Yeah,
don't,
they think it was like $20
yeah,
I remember it being
pretty
$20.
much to
And
try.
I think that was included in the PSI.
Yes.
to Tri-County Metro. I don't have it. They didn't order it. They asked for restitution, $20, but it's not a part of the probation JOS since they recommended straight time in this matter.
Okay, so I would be requesting that $20 in restitution.
All right. Have you been able to go through the pre-sentence report with your client, Ms. Schroeder?
I haven't, Your Honor. I have reviewed it, though. I do not believe there's anything in there that is problematic, or I do know that it definitely is. She's supposed to be going to try cap through the circuit court.
Right.
Yes.
All right. So based on your reading of the pre-sentence report, any additions, deletions, or corrections?
No, Your Honor, and I will just state the thing because she's been at the Eaton County Jail as well as I think the recommendation is for time served at this point. Which I
Right.
believe she's going to be objecting to, if I'm correct.
All right, and just for the record, I will indicate this case has been adjourned several times for transport issues or something of the like. But we have Ms. Moscow here, and we're going to proceed with sentencing. The recommendation from probation is time served so that Ms. Moscow can get into treatment or continue with treatment. Ms. Moscow, at this time, what treatment are you looking to get into?
So actually, Your Honor, I am waiting to go into the courtroom to be sentenced here, and I will be leaving for rehab on Monday. I will be going to either Heartline in Detroit or TriCap in Saginaw for 90 days, and then 2-year
Right.
drug court.
All right, and I have an indication from probation that both agencies are available, and they actually have TriCap here, but you may know more than they have. You may have more information than they have because this was taken on March 19th.
Your Honor, may I ask her a question?
Sure.
Ms. Moscow, do you acknowledge you have a right to review this report? But based on my representations here, you're all right with waiving that at this time, just based on the fact that we need to get your case so you can get
Well,
treatment?
we're running time served, right?
Yes.
Yes.
Okay, thank you. Just like you have a right to review it. I just wanted to know if you would waive it. Thank you.
All right. So this is for the guilty plea on September 5th, 2023. It is ordered the defendant spend 69 days in jail beginning March 25th, 2024. Credit is given for 69 days previously served. I don't see, this is a 93-day misdemeanor. So I don't see any advantage now that Ms. Moscow is on to rehabilitation, which it appears is a good idea here. You would agree with me, Ms. Moscow, that seems to be the best plan?
Yes, Your Honor, but today marks 90 days incarcerated here.
Okay, all right. So I'm gonna do 69, and would you, Ms. Schroeder, would your preference just be the time at the time of judgment of sentence, or 90 days with 90 days served?
Let's do 90 days, 90 days.
All
I
right.
think she's
Yeah,
entitled to all of it. because
I do too.
She hasn't been sentenced on the Clinton
All
County
right.
case, or not Clinton County, Eaton County.
So let's make it 90 days in jail with 90 days served. I'm gonna waive any fines and costs. I'm going to waive I'm not gonna order the crime victim's right fee or the state minimum cost fee for 75 and 120, since I'm waiving both those fees, or not issuing both those fees. And then I know the restitution is $20, but it doesn't make any sense to hold the case open for $20. So I'm not going to order any restitution in this matter, understanding that there is $20 out, but 90 days, so the sentence is 90 days in jail, 90 days served with no probation. Anything else? Any questions concerning the sentence, Ms. Schroeder?
No, Your Honor, thank you.
Ms. Wilson?
Yes, Your Honor, I'm a bit confused. You said you're not ordering restitution in this matter?
I'm not ordering the $20 because that would be the only $20 out.
Right, okay,
That wouldn't close the file.
okay.
So yeah, because there's fines and costs are waived, everything. So the $20 is I don't think it's enough to keep the file open. Yeah. So I'm not ordering $20 for the stuffed animal to Tri-County Metro.
Okay.
That was a recommendation, but it seems more money than it's worth to actually have somebody look at the file and get referred to collections. Let's just start with a clean path.
Thank you, Your Honor.
It is, the restitution is a constitutional right. I would just like to
Right.
place that on the record.
Right.
So I do have some concerns about that, but I understand the court's
All
position.
right, thank you. All right, so, Ms. Schroeder, anything on the court's judgment of sentence, concerning this matter?
No, Your Honor, I just would wish Ms. Moschall the best of luck going forward.
All right, Ms. Moscow, you're all set. This case will be administratively closed and you can be on your way to rehabilitation, all right?
Amen. Thank you. Take care.
All right, you too.
Bye now. Thank you, Mr. Sturtevant.
record in docket 24-00888. That is people of the state of Michigan versus Zachary Newby. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wanji.
And I'm here if you want you from Mr. Newby.
And sir, you are, and correct my pronunciation, is it Zachary Newby?
Yes, sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I have made an offer to the defendant. My offer was DB with 7694A status. It's my understanding that he is choosing to decline that offer, so we would be proceeding with the preliminary exam today. I do have my victim and my officer witness here.
All right. Are there any preliminary matters before we start the hearing, Ms. Wilson?
Other than the usual sequestration order, I don't believe there are currently any witnesses here in the courtroom.
All right, Ms. Wanji, is that a fair statement? And does the defense have any preliminary matters before we get started today?
None, Your Honor, thank you.
All right, so I'll leave the motion for sequestration. Just bring it to the court's attention. If there's anybody in the courtroom that should not sit through another witness's testimony, let me know and I'll make sure that that person is removed from the courtroom for sequestration purposes. And Ms. Wilson, when you're ready.
Thank you, Your Honor. The people would call JL Harrington.
All right, Ms. Harrington, we'll have you come up.
I'm gonna stand right behind you, Judge.
You're gonna stand right in front of me, and please spell your first name and last name for the record.
JAEL. Last name is Harrington, HARRINGTON.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Right, go ahead and have a seat right here next to me. The microphone is for recording,
Okay.
so please project as best you can. And let me know if that fan's bothering you, okay?
All right.
All right. All right, Ms. Wilson, when you're ready, you may proceed.
Thank you, Your Honor. Ms. Harrington, I'm gonna bring your attention back to October 25th of 2023. Do you remember making a police report that date?
October 25th?
I'm sorry, December 25th.
Yes.
Yes, okay. And what was that in reference to?
A dispute between my boyfriend and I.
Okay, and how long were you with your boyfriend?
We've been together for about 4 years.
Okay, so you have a pretty good idea of what he looks like. Do you see him here in the courtroom today?
Yes.
Can you point him out and describe something he's wearing?
Straight dude with the green jacket.
Thank you. Your Honor, I would request that the record reflect identification.
Any objection to the witness identifying the defendant, Ms. Wanji?
Not for the purpose of telling
For
them.
Thank you. For purposes of prelim, the witness is identified Zachary Newby.
So Ms. Harrington, where did this dispute occur?
At our home.
And do you know the physical address of that?
Yeah.
What is
550 Norman Street here in Lansing.
And that's in Ingham County,
Yes.
Michigan? Okay. So when you spoke to officers, were you at the residence?
No,
Where were you at?
I was at Sparrow.
Okay. And when did this dispute occur?
It had occurred hours before Christmas Eve.
Okay. And how did it start?
Honestly, I don't remember
Okay.
that much. I know I had woken up from like a drunken nap. And I was already kind of irritated just based off things that had happened prior, day before that didn't have anything to do with like that day or nothing. I just was in my own feelings, kind of, based off something I had seen in his phone and just being upset myself. And I don't know what I saw exactly that triggered me, but I just woke up and kind of was aggressive and just irritated and started yelling at him and just shoving him around and being the aggressor more so.
And do you recall initially telling police that you had shoved him,
That I had what?
that you had shoved him?
Yes,
You did tell them?
I believe so. I honestly can't. I can't remember everything that
Okay.
was
Would,
said in the first report.
Would
I was kind of out of my
reviewing
mind.
your statement to police help you refresh your recollection?
Yeah, I guess.
Okay. Your Honor, permission to approach.
You may.
And for the record, I am handing Ms. Harrington report number 23519-12742, and that is a report by Officer Antonio Sina. So Ms. Harrington, your statement starts here and it ends at the end of this page. If you can just read that silently, and then once you're finished, just go ahead and turn the report over. Okay, Ms. Harrington. Now, in reviewing that report, do you have a better recollection now of your statement to officers?
Yeah,
Okay, and did you tell officers that you had shoved him?
no,
Okay, and so at that time, did you remember shoving him?
the following morning, yes, I did. I will admit that I wasn't exactly truthful. I did say a lot of things in this report out of spite. It was more kind of just to, I guess, get him in trouble with his stuff up himself.
So we have a problem.
Yes.
Yes.
All right, so we have a problem. So, so I'm gonna direct Ms. Wilson and that she may need an attorney at this time.
Okay. Yep.
Because she may be, her additional statement may incriminate herself,
Yeah.
and she should talk to a lawyer before we go forward.
Okay.
And we should have a lawyer come in to indicate if she does choose to take the stand. Because if right now, she's right on the verge,
Yep.
or if she hasn't, she's right on the verge of incriminating herself in regards to her statements to law enforcement. I think that's fair. So it's my understanding that the witness can apply for a court-appointed attorney through the public defender's office. It'll most likely be conflict counsel because they're obviously the defendant is represented, and we'll have to adjourn this matter out, but she can do that. And you can get that number from Mr. Milks, Mr. Palmer, Ms. Wilson. You can get that number to make contact. I don't think they're going to take a financial application for you to see if you're indigent. This is really to protect you because you're right on the verge of maybe incriminating yourself. Okay. Second, you can always retain your own counsel. So you can always go out and get your own lawyer and spend money to get your own lawyer to be represented, even if you're denied by the public defender's office. But you should go through some rights you have as a witness in this case. Mr. Pfeiffer.
And Adam Pfeiffer, also on behalf of the people. What might be helpful is if Mr. Milks, Mr. Palmer has 5-10 minutes. I believe Mr. Palmer does, because we have the case following this. If maybe they could go out into the hallway with the witness and try and get her that information now, as opposed to any type of delay.
Yeah, I mean, I'm willing to take a break, and if you need me to give her the number, but I also don't want you to feel like you're in the middle of this Because you, because I've seen lawyers appointed from the bench and you're not appointed from the bench, but she should know what she's getting herself into.
I'm pretty sure Mr. Palmer's role here would be almost clerical in nature.
Yeah,
Yeah.
I can certainly handle it, Judge. We can fill out an application and turn it into.
All right, perfect. That way, there's no time spent. Miss Wanji, you understand the nature of. Did you need some time to talk to your client?
Yes, no.
All right, let's take about 5-10 minutes adjournment and we'll come back and we'll put it on the record.
All right.
All rise.
Thank you.
You see it.
So we're back on the record in docket 24-00888. That is people of the state of Michigan versus Zachary Newby. We took an adjournment to speak to the witness, and we also took an adjournment to have defense counsel talk to their client. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. Ms. Harrington is getting set up with the PD's office. I do have an officer here if the court is inclined to continue with that witness. But I would leave that to the court's discretion.
So I would be inclined to hear the officer's testimony if he's here. Ms. Wanchi.
I would be asking for an adjournment because the prosecutor knew that this was coming on, that they had a victim who was going to change her story. And I would like also our office to interview her so that we know how we're going to manage and even the questions that we're going to ask the police officer.
I'm assuming you knew the police officer was coming today.
No, that Miss Harrington was going to change.
That would be part of your preparation to cross-examine the police officer.
Police officers come on all of our DV cases, so that shouldn't be a surprise.
What I'm going to do is I'm going to take the testimony of the police officer in this matter, but the witness should not be present during the testimony. So she's part of the sequestration. So I will have the complaining victim removed from the court, ma'am. And then the officer can testify, and then we'll adjourn because.
And if I could just make one clarification, while I knew that Ms. Harrington had previously made a different statement to the detective, it was not what was said here today.
And what I'll do is we'll take the direct testimony of the officer, and then Ms. Wanchi, if you want to wait on your cross, you're more than willing to wait on your cross. We can bring him back for cross-examination if you're indicating that there are two statements but the direct examination of the officers then will take place now.
Okay. The people would call Officer Antonio Sina.
All right, so it is Officer Sina. You may come up, and I'm gonna have you stand right there. I'm gonna have you spell your first name and last name for the record.
Antonio, Antonio, Sina, Cena.
Please raise your right hand. Do you solemnly swear or affirm tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, have a seat. The microphone is for recording purposes, so please project as best you can. And Ms. Wilson, you may proceed.
Your Honor, before you begin with that, is the complaining witness free to leave for the day, given the fact?
That she's under the subpoena, so.
I would say yes, because she needs to get conflict counsel.
All right.
Ms. Wanji.
Yes, can I get?
We got a number, yeah, you check the email.
Perfect.
All right, thank you.
That's fine.
No problem. Just wanted to do that before you get started.
All right, Ms. Wilson, you may proceed.
Thank you, Your Honor. Officer Sina, where do you work?
For the City of Lansing Police Department.
And what's your position?
As a police officer.
What are your general duties?
Currently I'm assigned to the traffic units, but I work general patrol, responding 911 calls and enforcing traffic.
And were you working as a police officer on December 25th of 2023?
Yes, I was.
And at that time, you said were you working as a patrol officer?
Yes, I was.
Okay. How were you dressed on that date?
In a fully marked Lansing police uniform.
And on that date, were you dispatched to Sparrow Hospital?
Yes, I was.
And why were you dispatched on that date?
Sparrow nurse had called 911 to report a domestic assault on a victim. So I responded to the emergency room to take the statement from the victim.
And when you got there, did you make contact with the victim?
I did.
What did you first observe about her when you arrived?
She was emotionally distressed, emotionally compromised, and had visible injuries to her body.
Did you get her name at any point?
I did.
What was it?
I would need my report to remember the exact name.
Okay. Your Honor, may I approach?
May.
For the record, I'm offering Officer Sina report number 23519127442. And your indications there.
So you'll review that to yourself and look up when you're done.
Okay. I'm all set.
Okay, and what was her name?
Janelle Harrington.
And was there anything else notable about Miss Harrington when you arrived?
Well, she had already been examined by Sparrow staff, receiving medical attention. So she was, like I said, emotionally distressed. She was undressed, wearing a gown that would be common for anyone being admitted to the hospital receiving services. I did notice, aside from her emotional distress, crying, she did have injuries to her face and neck prior to even getting her statement.
Okay, and in speaking with her, did you obtain any information? Or, so you said you were responding for a domestic incident, is that correct?
Yes.
Okay, and when you were talking with Miss Harrington, did she give any indication about who had assaulted her?
Then
Yes.
I will object at this time because I understand that we can go victimless and that her statement can be also that the prosecutor can ask the officer to disclose what the alleged victim said. But based on what one of the reasons why the court can allow this kind of testimony is the truth, the truthfulness of the or the trustworthiness of the statement. And as we can say, we can see today, the alleged victim, the complainant came and she completely destroyed her. She tried to destroy her testimony. That's why she has a lawyer.
The nature of the objection is the credibility of the witness. A response.
Your Honor, thank you. I believe the intent of the legislature here was to admit these kind of statements in situations exactly like this because domestic violence has this sort of cycle. I will also note that Officer Stina took her statement on December 5th, which was almost a day after the incident. Typically statements are clearer and more truthful closer to the incident. So I think that this statement does still have its indica of trustworthiness as defined under the statute.
If I may, Your Honor.
You may.
There is a motive here. The victim said that she gave the statement to because she was mad at my client. So again, trustworthiness and bias. You know, she had a motive of lying that day. So again, I don't think that it meets the requirement to get the statement on the 768.27C.
All right, and that's what you're offering. The statement is under 768.27C.
I was intending to. I hadn't gone through my foundational questions to admit those questions.
So there is at least one foundation. I just want to clarify. You indicated it was Janelle Harrington. She identified herself as Jael Harrington without the N, Jael Harrington. That seems to be a discrepancy right now.
On the spelling of her name?
Well, you put an N in it and she did not.
Okay.
So I don't know. So is it the same person? That's what I've got JAELHARRINGTON as she indicated herself. And then the officer indicated he interviewed a Janelle Harrington. I'm assuming it's the same person, but I'm just looking for clarification.
Officer Sina, is it possible that you misremembered the first name or misstated it?
Yes, if I'm pronouncing it incorrectly, but
All right.
I do believe that this is the same person. Another physical attribute that I witnessed at the time is that the victim has a very distinct tattoo of the defendant's name on her chest.
Okay.
All right. With that clarification, I'm gonna let you finish your foundation on 768.27C, and then I'll make a ruling once we get there. I think the final question was, do you recognize the defendant?
No, it was, did you obtain any information about the relationship between the victim and the defendant?
All right.
Yes.
So I'm gonna allow that as foundation.
Okay, thank you. And without telling me what she said, did Ms. Harrington describe or explain why she was upset?
Yes.
Okay. And was it consistent with the reason you were dispatched?
Yes.
Okay. Did you learn when the incident occurred?
Yes.
Did you learn where it occurred?
Yes.
Was it in Ingham County?
Yes.
Okay. Your Honor, at this time, the people would ask to admit the statements from the victim to the officer. He was responding in his official duties. He was dressed in a uniform. The statement was made shortly after the time of the incident. So I believe the indicative trustworthiness has been met for this matter. I understand the defense has an objection for the bias portion. I again would reiterate that the legislature specifically intended for this statute to come in because of the nature of these types of relationships and the backtracking victims in this type of cycle tend to do.
All right. Thank you. Ms. Swanji, you can renew your objection as to the bias or motive concerning the factors that the court needs to weigh in regards to 768.27C. So I'll give you that opportunity. I do understand the nature of your argument.
And yes, I know, it's not just the, that the statement was made close to when it happened. Today, the alleged victim came and said she lied. And that's why the court is trying to find her an attorney there is also the trustworthiness of her statement. She said today that what she told the police that day seems not to be true, and we trying to get her an attorney to protect her rights.
And Your Honor, if I may, I never finished my direct examination for that reason. I may very well have impeached those statements to further indicate the trustworthiness of the statements I'm trying to get in here today.
Thank you. Pursuant to Rule 768.27C, the statement purports to narrate, describe, or explain the infliction or threat of physical injury, action in which the evidence is offered as an offense involving domestic violence. The statement was made near or at time of the infliction or threat of physical injury. Statement was made to a law enforcement officer as the officer indicated. I find that the initial foundation has been laid for 768.27C. In regards to the circumstances of trustworthiness, this statement at the time was not made in contemplation of pending or anticipated litigation. And at the time, the declarant does not appear to have a bias or motive for fabricating the statement at the time they made the statement. Now, afterwards, they indicated that they may or may not have. We weren't able to get into it since we had to appoint a lawyer for the witness. And so that's still an unknown. The witness is yet to be crossed, so we still have that as an unknown. The evidence was definitely corroborated at the time by the officer when he went and he saw the extent of not only the injuries, but now he's described as attached to, among other things. So I find that all the circumstances of trustworthiness fall on the side of allowing 768.27C at this preliminary examination level to allow the officer to continue to testify, essentially piercing confrontation on some level. So at this time, you may proceed, Ms. Wilson.
Thank you, Your Honor. Officer Sino, what did Ms. Harrington say happened?
She told me that she was currently living with her boyfriend, Zachary. She said that the night prior, Zachary and a friend named Ernest were drinking at the house. During the night, a verbal argument had broke out between her and Zachary after Zachary became upset, feeling that she verbally disrespected him. She referred to him as a derogatory term, which embarrassed him in front of his company. The two began arguing, went into a bedroom where the argument became physical. She stated to me that she was assaulted physically. She was strangled. She was thrown to the ground. She was struck in the face numerous times. The assault occurred in the bedroom, fell out into a living room. Eventually, she indicated that she was able to fight for her escape, retreated out a back door where Zachary continued to assault her, pushed her down. She fell and hit her head on the asphalt, but eventually was able to get a set of car keys and flee the scene.
Okay, and you said that she had been strangled. Did she describe how exactly that occurred?
She indicated to me that Zachary was standing over her, used two hands wrapped tightly around her neck. She indicated that she did not lose consciousness, but did struggle to breathe. And then her purpose of fleeing the scene was that she was scared for her life.
Okay, and you said when you arrived at the hospital, you saw injuries, is that correct?
I did.
Did you take photographs of those injuries?
I did.
Okay. For the record, I am showing Defense Counsel Exhibits 1 and 2. Okay, and Your Honor, may I approach?
You may.
And I am handing Officer Sina People's Proposed Exhibits 1 and 2. Officer Sina, do you recognize those?
Yes, I do.
And what are they?
These are the photographs that I took the day that Ms. Harrington was in the hospital.
And are they a fair and accurate depiction of what you saw that date?
Yes.
Okay, and permission to publish to the court, Your Honor?
Any objection to the admission of People's Exhibit 1 and 2, Ms. Wanji?
No, Your Honor, thank you.
Without objection, People's 1 and 2 are admitted into evidence.
Thank you, Your Honor.
And you may proceed, Ms. Wilson.
And I have nothing further for this one.
All right. Ms. Wanji, you can cross-examine the witness now. Since you're indicating that this is somewhat a surprise, you may, and we know we're coming back, you can wait to have your cross-examination later, or you can start your cross-examination and finish up at another date. It's entirely up to you.
I'm going to finish up, but I'm going to do it next time.
All right. So Officer Sina, you're still on the stand, subject to cross-examination. We'll continue your subpoena to the next time. Thank you for your appearance today.
Thank you, sir.
All right. So I would think that we're adjourning.
If I may just enter one more exhibit, People's Exhibit 3 under 766.11B. It is a medical report, and I believe that the statute allows for admission without a foundation and preliminary exam.
It does at preliminary examination. Has counsel had the opportunity to review that?
We did show it before.
No.
And so people would move for the admission of People's Exhibit 3.
Motion to admit People's Exhibit 3. Any objection, Ms. Wanji?
I leave it to the court discretion.
All right. The court will admit People's Exhibit 3 pursuant to the statute, and then we will grant an adjournment. I assume an adjournment really at the court's request, but also at both attorneys' request, that the witness get an attorney, and then we will recross-examine Officer Sina pursuant to Ms. Wanji's request. So we will reset this preliminary examination for, do you intend to call any other witnesses?
Just the officer.
Just the officer.
Yes, yeah.
So we have cross-examination of the officer.
And
We don't know yet.
how far?
What's the time frame?
If I could get 2 weeks for subpoenas.
Weeks for subpoenas? So this will be rescheduled for May 2nd at 9:30. I will return exhibits 1, 2, and 3 to the people.
Thank you, Your Honor. May I approach?
You may. And we've reset this. We're set for cross-examination of Officer Sina. And then we'll wait and see on the witness. Anything else for the record in 24-00888? It's been rescheduled for May 2nd at 9:30.
Not from people, but thank you.
Ms. Wanji.
Nothing, Your Honor, thank you.
All right, we'll see you back here on May 2nd at 9:30.
And then, Your Honor, if we wanted to do a quick waiver of Mr. Hayes of the
Sure.
prison. Who? Oh, yeah, she's gonna be late.
I'm gonna go.
Yes.
See you.
Mhm.
Right, so Marcus Hayes.
Yes.
All right.
Oh, all right.
All right, so we're on the record in docket 23-02316. That is people of the state of Michigan versus Marcus Hayes. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Mills.
Hey, good morning, Your Honor. Stephen Milton, on behalf of Mr. Hayes. Mr. Hayes is present and staying to my right at this time.
And sir, you are Marcus Hayes, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a preliminary examination today Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe this is going to be a waiver of the preliminary exam. There has been an offer from the people that will remain open until pretrial in circuit court. And the offer is to plead to 1 count of uttering and publishing with restitution.
And is that a fair and accurate statement, Mr. Milks?
It is, Your Honor. I will note my client does have a matter that is already pending upstairs. I've already been in contact with the prosecutor upstairs and done continuing negotiations with the prosecutor's office.
All right. So at this time, their negotiations are to continue. The offer's been extended and negotiations are to continue.
Yes, and thank you, Your Honor.
All right. May I inquire of your client, Mr. Milks, of his waiver of the preliminary examination?
Yes.
Preliminary examination. Mr. Hayes, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence the identity of the person who committed the crime and that a crime was committed. Yes. You are represented today by Mr. Milks, Stephen Milks, who would be available at the prelim to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir? Yes, Your Honor. It's my understanding that an offer's been made. Negotiations are to continue in circuit court. It is your wish today to waive your right to this preliminary examination and have your case bound over to circuit court as charged at this time with an open offer and negotiations to continue. Is that correct? Yes, is it your wish today to waive your right to a preliminary examination? Ms. Wilson, do you also waive the people's right to preliminary?
The people unconditionally waive their right to an exam.
Okay, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide that documentation to both counsel to sign.
Pen on you.
Yeah.
Yeah, that's much. I was thinking.
All right, I'm in possession of the bind over documentation on docket 23-02316. I'm going to indicate the examination has been waived on today's date, which is 4/18/2024. Prior to signing the documentation, anything else to come to the court's attention, Ms. Wilson?
Not from the people, thank you.
Mr. Mills?
No other defense. Thank you, sir.
All right, I will sign the bind over documentation. So your time in district court is now done, sir. You will get your next date from your attorney, Mr. Milks, in circuit court. Okay, sir?
Okay.
All right. Anything else for the record in 23-02316, Ms. Wilson?
Nothing for the people.
Mr. Milks?
No, thank you, Your Honor.
You're all set, sir. All right, so let's compare. Who do we have left, Ms.?
Well, actually, since I'm already up here,
We
we can
also
already
have
do.
Mr. Jamel Williams, which I believe is just going to be an adjournment.
All right, so Williams is here and is the other one Hats?
Tats is running late allegedly,
Okay.
so
Show for the people would very much like the other Williams matter to go
yes,
after
after
this.
that, yes.
I have a victim who is a minor who's been waiting here.
All right, and so that's Jamel Williams.
Jamel Williams is the adjournment. Michael Williams would be
Well,
the exam.
We're gonna be contesting the adjournment.
I'm sure you will.
But, yeah.
All right, so Michael Williams is the exam.
Yes.
All right, and Jamel Williams is the request. And who do you have ready to go?
I believe Jamel Williams will be ready for,
The
I'm
request.
hoping
We're
an
ready.
adjournment, but.
We're hoping for dismissal.
And then we'll do Mr. Pfeiffer's Michael Williams case.
Thank you.
All right. And that's with Mr. Palmer.
Yep.
Yes.
He's here.
I'm here.
He's hiding.
All right, so we're on the record in docket 24-00830. That's people of the state of Michigan versus Jamel Williams. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Mills.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Williams. Mr. Williams is present and staying to my right at this time, Your Honor.
And sir, you are Jamel Williams, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. I'll indicate that on April 11th, we left this on for, and we had some discovery still out. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. So we had a bit of a mix up with the one of the discoveries. It was placed in the wrong spot. So defense counsel has not received it yet. It's my understanding it's in the correct spot now, ready for pickup. I did also discover last night that there is additional discovery on Axon that I was not aware of previously that I haven't reviewed, and I know defense counsel hasn't reviewed. So I would be requesting an adjournment.
All right, Mr. Milks.
Your Honor, the people are also not ready to proceed today, as my understanding. It's a bizarre kind of situation that we're in where the people are asking for an adjournment for the benefit of the defense when they're not ready to proceed forward. At this time, as purposes of today, we don't need that evidence. We're ready to go forward right now. So everything that was just stated is sort of moot. And unless the people are ready to go at this time, we're asking for dismissal.
All right, thank you. I find just cause to adjourn the matter. It would appear that there's some discovery still out. It would appear that the people are, that although the people are unable to proceed today, this would be the first request for an adjournment to get your witnesses here, et cetera. So I think I do the same for defense if they were putting on any proofs today. But as we continue and you don't have witnesses here, there's going to be a problem. So I find just cause. So Mr. Williams doesn't waive any rights today concerning this matter. I found just cause to adjourn. I'm assuming, Ms. Wilson, that the rest of the discovery will be made available to Mr. Milks so that he can zealously advocate for his client.
Yes, it will, Your Honor. Thank you.
All right, we'll adjourn. What time frame are we looking at? Just enough for your subpoenas?
I know that the discovery is quite a bit.
Okay.
So I guess I would leave it to defense counsel.
Right, it's 6 counts.
Just
Across 3 different police reports and a wholesale dog.
So how much time do you want to, and then we'll get as close to that as possible.
We were made aware of the cell dump, I think just the other day. We checked to see if someone from my office picked it up yet. I don't think they
They
did.
hadn't, no, because it was not in the PD pickup spot.
So I would think a just cause adjournment for more time than less for you to review. And I'll warn you, May is problematic.
May is problematic for me as well.
Yeah, because so let's look at the date, because the date there's a holiday in there, and then I'm out for 2 weeks. So
Is May 2nd available, Your Honor? And it's 2 weeks away, but I also don't want to push this out so long for my.
I think May 2nd would be available.
It's 2 weeks away.
Yeah, so you're gonna have lots of people. We're all gonna be very well attended, but it'll be May 2nd at
8:30.
May 2nd at 8:30. And that should give the requisite time to get the subpoenas out, and hopefully discovery will be transferred. Anything else for the record in 24-00830? This is a just cause adjournment to May 2nd at 8:30. Ms. Wilson.
Not for the people, thank you.
Mr. Milks.
Enough from the defense. Thank you, sir.
Okay, we're all set. Thank you for your appearance today.
Thank you, Your Honor.